The Federal Parliament just introduced a major change to the Fair Work Act that affects most Australian workplaces: the right to disconnect from work after hours. This new law fundamentally changes how businesses can interact with their staff outside of work hours. The changes started on 26 August 2024 for businesses with 15 or more employees and will take effect for small business employers with fewer than 15 employees from 26 August 2025. I'm Adrian Barwick, Solicitor Director at WilliamsonBarwick, a specialist employment and industrial law firm, and in this video I'll break down what qualifies as reasonable versus unreasonable contact after hours, how this affects different roles, from managers to part-time staff, the exact steps employers need to take to comply with the law, when employees can legally refuse to respond, and how disputes will be handled by the Fair Work Commission. Let's start with what this new right means for your workplace. Under Section 333M of the Fair Work Act, the right to disconnect gives employees the legal right to refuse monitoring, reading or responding to any work-related communications outside their working hours unless the refusal is unreasonable. While the law does not prohibit employers from contacting workers after hours, employees can legally decline to engage in these communications unless the refusal is unreasonable. This includes all forms of contact, whether it's emails, phone calls, text messages, or any work messaging platforms. This right extends beyond just employer communications. It also covers contact from third parties like clients, suppliers, contractors, or customers about work-related matters. However, employees can only refuse contact from those persons if their refusal isn't deemed unreasonable. When determining whether an employee's refusal is unreasonable, Section 333M3 of the Act sets out specific criteria we need to consider. These include the reason for the contact, how disruptive the contact is to the employee, whether the employee's salary includes compensation for after-hours availability, the nature of their role and level of responsibility, and personal circumstances, such as family commitments. For example, if a senior cost manager who's being paid a salary which compensates for all hours worked is contacted shortly after work by his manager to urgently assist the client by the next morning, it may be unreasonable for the employee to refuse to respond to the manager's contact. However, it might be reasonable for a part-time event coordinator who works standard hours to refuse to answer a call at 10 p.m. about catering requirements for an event in 2 weeks' time. Now, while the new right to disconnect in the Fair Work Act will apply to all national system employers and employees, you will also need to consider applicable terms in any modern award or enterprise agreement that applies to your employees. On 26 August 2024, the Fair Work Commission varied modern awards to include the right to disconnect. And the award may clarify how the right to disconnect works with things such as emergency roster changes, standby, and callback clauses in the awards. For example, an employee may be required to respond to contact when paid an on-call allowance and the contact is to recall the employee to work. If an employee is covered by an enterprise agreement and the enterprise agreement includes a right to disconnect term that is more favourable to the employee than the rights under the Fair Work Act, the right to disconnect term in the enterprise agreement continues to apply to the employee. Now we've covered the legal framework, let's turn our attention to practical implementation. For employers, managing the right to disconnect isn't a simple one-size-fits-all solution. Some steps that employers can take to manage the new right to disconnect include: first, reviewing employment agreements, including a review of the hours of work term and whether it specifies out-of-hours work may be required to be performed. Terms that identify compensation paid for additional hours, including salary and allowances. Terms relating to overtime, rosters, on-call, recall to duty and time in lieu. Second, consider updating the position description to reinforce role expectations around out-of-hours work, such as night shifts or weekend work, on-call duties, emergency responses or roster changes, or the need to monitor phone calls, texts or emails after hours. Third, employers may wish to implement a new communications policy that defines expectations around out-of-hours contact for staff and managers and includes a mechanism to deal with disputes. And lastly, training managers, supervisors and team members on the employer's policy and expectations around out-of-hours work. Should a dispute arise about the right to disconnect, employers and employees should try to resolve disputes at the workplace level. If that is unsuccessful, the dispute can be dealt with by the Fair Work Commission. The Commission can make orders for the employer to stop contacting the employee after hours, or if it finds an employee's refusal to respond is unreasonable, it can order them to stop taking certain actions. Failure to comply with FWC orders can result in a penalty of up to $19,000 for an individual or up to $94,000 for a corporation. The right to disconnect is also protected under the general protections provisions of the Fair Work Act. This means employers cannot take adverse action, like dismissal or any other form of prejudicial treatment, against employees who exercise their right to disconnect. If you need specific advice about implementing these changes in your workplace, please contact our office. You'll find our details in the description below.